ready or not, I'm going to start. You're welcome to keep chewing, but in an effort to get through the program and get you out of here on time, I'm going to begin. And I can talk loud right over you. I want to welcome all of you to the annual meeting of the members of the Michigan Supreme Court Historical Society. This is our 10th annual luncheon. And of course, your attendance here today and your continued interest and support of the Society are greatly appreciated. 2001 marks the 13th year of the Society's activities relating to the history of the Michigan Supreme Court. Since its beginning as a territorial court in 1805, 112 justices have served on Michigan's highest court. We're here today to honor all of them, all who have served, but particularly those who sit on the court today, who will soon be introduced to you by our Chief Justice, but also those who have relatively recently completed their service. So I'd like to take this opportunity to recognize and have you recognize the former justices who are with us today. Chief Justice Thomas E. Brennan, Justice Robert P. Griffin, Justice Charles L. Levin, and Chief Justice Dorothy Comstock Riley. We appreciate their continued support and involvement with the Society. I'd also like to ask you to recognize the living former justices who are alive and well, but who are unable to join us today. I remind you of their names: Justice Dennis W. Archer, Justice Patricia J. Boyle, Chief Justice James H. Brickley, Chief Justice Mary Stallings Coleman, Chief Justice John W. Fitzgerald, Justice Lawrence B. Lindemer, Chief Justice Conrad L. Mallett Jr., Justice James L. Ryan, and Justice Theodore Soros. There are 13 living former justices. May I present to you the President of the State Bar of Michigan, who's here, Tom Ryan. Tom, will you stand? Society has always had a good relationship with the State Bar, and recently, in fact today at our meeting, we elected John Berry, the new Executive Director of the State Bar of Michigan, to serve on the board, replacing Georgie Bushnell Jr., who has retired from the board. There are a few people who aren't here today who were going to be here today, and the reason they're not here is because they're attending the funeral of Richard Austin, our longtime Secretary of State. Richard Austin was on the Historical Center Foundation Board, another board interested in history, and had a deep interest in history of the state of Michigan, and even though he was in the executive branch, he also had an interest in the court. I think it's appropriate just to take a moment of silence and let each of you in your own way say a little prayer for the memory of Justice, or for the memory of Secretary of State Richard Austin. Okay, let me take a moment now to report on the recent activities of the Society. Our membership base remains strong. We appreciate those of you who have come today to make your contribution to our cause. Those of you who are not members of the Society are certainly encouraged to join. Membership information is available on the table. You'll see the sign-up folder, and it's also available at the registration table. As many of you already know from reading the year in review issue of Society Update, the Society has had a busy year and is looking forward to several new projects in this year. Last year, the Society assisted in awarding a legal milestone to former Chief Justice Mary S. Coleman at a State Bar of Michigan ceremony in Battle Creek. Very well attended. Mary Coleman was there. It was just a nice day. We continued our portrait procurement program by aiding fundraising activities and committees for several portraits, including Justices Boyle, Brickley, Mallett, and Weaver. Those are all ongoing portrait committees, and if you are interested in contributing to any of those justices' portraits, you may contact the office and we'll direct you to the portrait chairman. In addition, the Society has commissioned the painting of two posthumous portraits, those of Justices Neil E. Reed and Justice Edward M. Sharp. And with those two, that will complete a collection of actual portraits of every justice of the Michigan Supreme Court who served in the 20th century. We have an unusually good actual portrait collection in our court of 112 total justices. Historical Society joins the court in looking forward to a dedication of the new Hall of Justice. You remember last year we had the pictures of the hall. It's up, the hole is dug, and the steel is up. The building is progressing, and it's scheduled to be completed in the fall of October 2000. And the Chief Justice tells me it's on schedule, and a tentative dedication date has been set for October 15 of 2002 for the new Hall of Justice in Lansing. The Society is cooperating with the court in the development of a learning center, which will be located in the new Hall of Justice and which will be open to the public. We also look forward to the advancement of all of our existing programs, including the gathering of oral histories of former justices, continued development of court history educational materials, and the continued research of the personalities, decisions, and events that have shaped the story that is the history of the Michigan Supreme Court. Once again, let me repeat our gratitude for the continued support of all of our members. If you look in your program, you will see a list of firms, and in particular, we want to thank those law firms who have become law firm members of the Society by their annual contributions of $1,000. To express our appreciation to these firms, the Board of Directors of the Society would like to present each firm with a certificate of giving. I would ask those persons accepting the certificate on behalf of their respective firms to please come forward as I read the names of the firms, and our Secretary, Charlie Rutherford, will hand you your certificate of giving. Daniel M. Scher, accepting for Barris, Sott, Dean, and Drecker. Richard E. Rassel, Dick Rassel for Bussell Long. J. Thomas Linga for Clark Hill. Gilbert Cox for Cox, Hodgman, and Primerico. Bernadette Dennedy for Dixon Wright. Lawrence D. Connor for Dykema Gossett. Tom Howlett for the Gugasian firm. Mark A. Stern for Honickman, Miller, Schwartz, and Cohn. Thomas G. Kienbaum for Kienbaum, Upper, Wall, Hardy, and Pelton. And Mark Shea for Riley, Rommel, and Conway. The support of these firms, in addition to all of you as members, has allowed the Society to expand several of its programs and to begin extending the information that we can offer to the public about the Society. Other firms, of course, are welcome to join the firms supporting the Society. Many of the people in those firms are individual members of the Society, so in effect they're doubly helping us. While Charlie's finishing that, I want to call now on Chief Justice Maura Corrigan to bring you, the members, the greetings of the court and to introduce her colleagues.
Good afternoon, and thank you, Wally, and members of the Board of Directors of the Society for this afternoon's programs and today's festivities. Our court is, of course, very grateful for the voluntary work that the Society does on behalf of the court, and we especially commend the law firm givers who are making it possible for the Society's work to be expanded. The most serious business of ensuring the survival of our constitutional order really depends on the men and women who currently serve on the Michigan Supreme Court in the state of Michigan. But it seems to me that the work of preserving the history of the court extends beyond that small group of men and women. The work of protecting our history and thereby promoting reverence for law really belongs to all of us. And so I thank you on behalf of my colleagues on the court for what you are doing and for the fact that you have stepped forward to assist the court in preserving its history. I would like to mention a couple of things to you. But Wally already mentioned to you the fact that October 15th of 2002 is the date for the opening of the Hall of Justice. Finally, the Supreme Court, the Court of Appeals in Lansing, and the State Court Administrator's Office will be headquartered in one building for the first time in our state's history, and we're delighted about that. We look forward in the fall to the presentation of Justice Boyle's portrait to the court, and also we're working now on celebrating in some fashion Detroit's 300th birthday by preparing a vignette of Supreme Court history, Michigan legal history, to present to the mayor of Detroit in honor of Detroit's 300th birthday. So we continue our joint work with society. As Wally explained to you, unfortunately, due to the funeral of Richard Austin, our colleagues, Marilyn Kelly and Mike Kavanaugh, are unable to be here, and Justice Young is in California attending a conference. But I would like at this time to introduce the members with whom I serve on the Michigan Supreme Court. Sitting down here is our colleague Cliff Taylor. Cliff, do you want to stand? And my predecessor, former Chief Justice Elizabeth Weaver. Betty. And Steve Markman, Justice Markman. We just finished our weekly conference, and I can tell you how seriously these justices, and all the justices for that matter, take our responsibility to the people of Michigan. It's an honor to serve with these individuals. On behalf of the court, I thank you all for who you are and what you do in our state. Thank you.
The story of the Michigan Supreme Court is one that is rich with character and one that is made more interesting through the exploration of the lives and the personalities and the actions of those who played the biggest part in its formation. That is, the justices themselves who have served on the court. 10 years ago now, at our first annual luncheon, which was held over at the Detroit Club, Tom Brennan gave the first legal vignette. He talked about the Michigan Supreme Court members, and he noted how the character, culture, and chemistry of the court changed each time one or more of the members changed. The mix and match of its members constructed the composite of the court and made up, if you will, the bench. Following that theme, author Brennan created his own version of a bench, not in a vignette, but this time in a full-length novel in book form. Here today to weave for you a tale and perhaps to unravel the mystery of some of the court's characters is former Chief Justice of the Michigan Supreme Court, founder and president of Thomas M. Cooley Law School, and now author, Thomas E. Brennan.
Warned me that the ball game starts at 1:05. We're already late. So we want to go over and watch the 8th loss in a row. In August of 1973, I called a news conference to announce my resignation from the Michigan Supreme Court, effective at the end of that year. Someone asked me that morning if I had any reflections on my years on the court, and particularly on my 2 years as the youngest Chief Justice in the court's history. Well, I was in a pretty jocular mood that day, and so I went for the laugh line. I told them that I planned to write a book which would reveal all the inner secrets of the Michigan Supreme Court. I said that the working title of that book would be, I was a teenage Chief Justice. I don't know, maybe that was the genesis of my novel, The Bench. If so, it took me 25 years to get around to it. Somebody wanted to know why it took so long, and I thought of the old joke about the elderly couple who hated each other and went to their lawyer to get a divorce after 67 years of marriage. When the lawyer asked them why it took so long for them to come in and see him, they said they were waiting until all the children were dead. Certainly it is a comfort to any chronicler of events to know that there is no one still living who can contradict what you say. In truth, of course, The Bench is pure fiction. If anything written by a sentient human being can be described as pure. I think everyone who writes fiction brings to the task a lifetime of experiences, feelings, mental pictures, and uncatalogued memories which reveal themselves between the lines. When I was at the keyboard, I didn't say to myself, this fellow is Mike O'Hara, or that one is Gene Black. Still, when you write fiction, you're sort of putting down on paper a description of a movie that you're seeing in your imagination. And sometimes in my mental movie, Bob O'Leary looked like Mike O'Hara. And sometimes he looked like John Swainson. And sometimes he looked like Gene Hackman. To be sure, some of the events I describe in the book are echoes of things that I experienced or heard about when I was on the court. For example, Jim Malloy gets elected Chief Justice on his first day as a member of the court. My own election as Chief didn't happen that fast, although the conspiracy between Malloy and Alton Henry in the book was indeed similar to my own relationship with Gene Black during the 2 months between my election and the start of my term. Black was very much opposed to Thomas Matthew Cavanaugh at the time, and he wanted him ousted from the Chief Justiceship. I knew next to nothing about the history of the court's infighting over the office of Chief Justice. But over the next few years, I managed to piece much of the story together, bit by intriguing bit. There are still many parts of it, I'm sure, that lie unreported in the memories of the very few players who are still around. Really, to appreciate the events I want to share with you today, we have to go back a ways in history. Of course, this being an historical society, I suppose that's not altogether inappropriate. The Supreme Court of Michigan began, as I'm sure all of you know, as the concurrent sitting of the several circuit courts of the state. The Constitution of 1850 confirmed that practice, but included some language which looked toward the creation of a separate appellate tribunal. First, it gave the legislature the authority to create a Supreme Court, but not for 6 years. Second, it spelled out several features of whatever Supreme Court was to be created by the legislature. It was to consist of a Chief Justice and 3 Associate Justices. They were to have 8-year terms. No 2 justices' terms were to expire in the same year. And the third provision was more than a little confusing, if not contradictory. The Constitution provided that once the legislature created a Supreme Court, it could not be changed or discontinued for 8 years. In 1851, the legislature provided that the circuit judges should elect one of their number every 2 years to be the presiding judge of the Supreme Court, but there was no such office as Chief Justice. When the 6 years were up, the legislature created the first full-time Supreme Court by Act 146 of 1857. It followed the language of the 1850 Constitution and provided for a Chief Justice and 3 Associate Justices and 8-year terms with 1 term expiring every 2 years. The Republicans nominated George Martin to be Chief Justice, and he was elected to that office in 1858. As it turned out, Martin was the first and only elected Chief Justice of the state of Michigan. He served until his death in December of 1867. I don't know whether it hastened his demise, but previously that year, the legislature had adopted Act 40 of 1867, providing that the Chief Justice was to be the justice of the court whose term was next to expire. I don't know how Chief Justice Martin felt about that statute. Certainly, a strict constructionist would argue that when the Constitution says a Chief Justice to be chosen by the electors, it means a Chief Justice chosen by the electors, and not in some other way. But apparently the legislature took the words banning any change before 8 years to be a carte blanche authority to make all sorts of changes after 8 years. In any case, after Martin's death on December the 15th, 1867, there was a hiatus of some 16 days, and then Thomas M. Cooley was selected as the second Chief Justice of the Court. In obedience to the legislative mandate, the job of Chief Justice was then passed along to the next man up for re-election every 2 years until the court was expanded in 1905. After 1905, there were 8 justices with 2 terms of office expiring every other year. So we entered upon what, for want of a better description, might be called the dual Chief Justice era, in which both of the justices whose terms next expired were designated Chief Justice, but they were required to divide the duties between them, with the senior justice serving during the first year and the junior justice serving during the second year. Now, for those of you who may not grasp the political significance of this arrangement, let me explain. In those days, the justices were elected in spring elections in the odd number years. Their names were on the ballot in April. The Chief Justice, being the spokesman for the court, was in a position to be more publicly visible than his colleagues. Thus, the benefit of publicity was given to the justices next scheduled to go before the voters. Now, as between being Chief Justice for the 12 months in the year before the election and being Chief Justice for the 3 months immediately preceding the election, it was apparently thought that the former was the more advantageous, and so the senior man got that assignment. The dual Chief Justice system, perhaps better named the annual turnover system, continued in effect from 1905 to 1956. The story of how and why that system ended really begins in August of 1946, when a 42-year-old Attorney General from Holland, Michigan, by the name of John R. Detmers, was appointed to the Supreme Court. Detmers was by far the youngest member of the court, and thought by some to be the youngest ever appointed up until that time. He went before the voters in April of 1947 to fill a vacant term to expire in 1953. But he didn't get to be Chief Justice either in 1946 or in 1947, since Justices Butzel and Carr, whose terms expired in 47, were in line for the job. So it was not until 1952 that John Detmers got to share the dual Chief Justiceship. He and Justice Walter North were up for re-election in the spring of 1953. North was the senior man, so he became chief on January 1st, 1952. Detmers, as the junior of the two, was to be chief in 1953. But Justice North died on July 23rd, 1952, leaving a vacancy not only in his term as justice, but also in the office of Chief Justice. It doesn't take a rocket scientist to figure out what must have been going through John Detmers' mind at that point in time. He was facing re-election in 7 months. The plum of the Chief Justice's chair was available, and he was now the senior man of those whose terms were next to expire. He surely must have been salivating over the prospect of being selected. But he wasn't. The center chair was left empty for nearly a month. And then on August the 14th, 1952, just 2 days before the Democratic State Convention, Governor G. Mennen Williams named his legal advisor, Clark Adams, to the Michigan Supreme Court to succeed Justice North. The judicial roster at the beginning of volume 334 of the Michigan Reports discloses that Clark Adams of Pontiac became Chief Justice on that very same day, August 14th, 1952. As a matter of fact, the records of the court show that John Detmers did actually begin to function as the court's Chief Justice after the death of Justice North. He signed orders of the court as acting Chief Justice as late as August 21st, 1952, a week after the Adams appointment. It was yet another week, on August 27th, when the court's orders began to bear the signature of Clark Adams as Chief Justice. Still later, Detmers presided at a special memorial session of the court on October 14th, 1952, honoring Justice North. A week after that, Clark Adams presided at the special session marking the retirement of the court's longtime clerk, J. Mertz. I've searched the state library and the state archives, but I can find no clue as to why that happened. One can only speculate that since Adams had to run to fill the one-year balance of North's term, and since that special election was to be in November of 1952, he was given the benefit of exposure during the autumn campaign. Adams won that race, defeating Detroit College Law Dean Charlie King. But who made Clark Adams the Chief Justice? There was no authority for the court to vote for a chief, and anyway, it's unlikely that the court would have met and acted on the very day that Adams was appointed. Yet the record shows he was chief on the day he was appointed. I thought perhaps that Soapy had designated him as chief in the appointment, but the newspaper doesn't say that he did, and I can find no record to that effect. In any event, Detmers took over on January 1st, 1953. In the following spring, both Adams and Detmers were on the ballot, along with former Governor Harry F. Kelly. Kelly led the ticket by a wide margin, leaving the two incumbents, Detmers and Adams, to duke it out for the remaining seat. Detmers won in a squeaker. By the way, for those of you who may think that virulent partisanship in the Supreme Court elections is a criticism of recent genesis, I recommend reading the 1952 newspapers. While Justice Butzel and Carr were sharing the CJ's duties in 1954 and 1955, the legislature was once again tinkering with the office. Act 142 of 1954 came to be known as the Permanent Chief Justice Law. It provided that beginning in 1956, the members of the court would elect one of their number to be Chief Justice, and that person was to serve as the Chief Justice for the balance of his term as a Justice of the Court. When crunch time came in January of 1956, we have another one of those curious, inexplicable episodes. Volume 344 of the Michigan Reports tells us that Edward M. Sharp of Bay City was Chief Justice of the Court for 5 days, from January 1st, 1956 to January 6th, 1956, when John R. Detmers became Chief Justice. The newspapers reported that Detmers had been chosen by his colleagues as the first permanent Chief Justice of the Supreme Court. It was while contemplating the mystery of the 5-day tenure of Edward Sharp that I came to realize why both he and Clark Adams held the office. First, you have to bear in mind that we are functioning under the dual Chief Justice or automatic annual turnover system. There was no vote of the court involved. The question of who was the Chief Justice at any given time was supposedly settled by the statute. Now add to that scenario the fact that in August of 1952, when Clark Adams was appointed, J. Mertz was still the clerk of the Michigan Supreme Court. Mr. Mertz had been appointed to that office in 1916. For all practical purposes, he ran the court. He was an extremely bright, experienced, gruff, dominating personality, one of the most colorful characters in the kaleidoscope of the court's history. One of his duties was to prepare and issue formal orders of the court. He had to have them signed by the Chief Justice. So he would have had to decide who was the person to sign the orders. In short, I am convinced that Clark Adams was designated Chief Justice of the Michigan Supreme Court by no less a final and incontestable authority than the clerk of the court, Mr. J. Mertz himself. And if that is so, it follows that Edward Sharp was similarly elevated to the highest judicial office of the state by Mertz's successor, the indefatigable Hugh Carpenter, who had prepared himself for the awesome power of the clerk's office by apprenticing under Mr. Mertz for no less than 30 years. When you think about John Detmers being thwarted in his career aspirations by an officious court clerk with a thumb-worn copy of the compiled laws in hand, you are immediately put to wondering how much Mr. Justice Detmers may have had to do with the enactment of the Permanent Chief Justice Law. I did a little exploring to see if I might find some evidence of John Detmers' DNA on Act 142. All I could find was that the bill was introduced by Lewis Crampton, an old-line Republican legislator and former circuit court judge, and delegate to the GOP National Convention in 1940, 2 years before John Detmers became chairman of the state Republican Party. Whatever Detmers' role was in that legislation, it would be naive to suppose that he was either unaware of it or indifferent to it. So John Detmers, as the legislatively designated permanent Chief Justice, served in that office for the next 6 years. He was in the prime of his career, not yet 60 years of age. In some ways, Detmers was the father of our modern Supreme Court. On his watch, the Office of Supreme Court Administrator was created. The Judicial Conference of Michigan, the annual gathering of the state's judges for in-service training and exchange of information, was established as well. Dethmers himself rose to national prominence. In 1957, he was chosen chairman of the National Conference of Chief Justices, and by the middle of the next year, he was on the short list for appointment by President Dwight D. Eisenhower to the United States Supreme Court. Unfortunately, John's deeply ingrained conservatism, combined with his unvarnished Midwestern candor, stifled his chances to go to Washington. Those were the days, as you may recall, of the Earl Warren Court, in which Eisenhower's disappointing appointment was unexpectedly and vigorously leading the nation's high court into an era of newly defined constitutional rights, especially in the criminal justice system. If anything, Dethmers was the poster boy for strict construction. And when, as chairman of the National Conference of State Court Chief Justices, he gave a blistering critic of the High Court's record at an American Bar Association banquet, Earl Warren, who was seated just a few feet away on the dais, was visibly angered. So much so that he promptly quit the American Bar Association and was not reconciled with that organization until many years later. Unfortunately for John, the Los Angeles ABA meeting was the high watermark of his judicial career. He didn't know it at the time. He went to bed on October the 13th, 1958, having been assured by a major Republican source in Cleveland that the president would announce his nomination to the United States Supreme Court the next morning. The heads up was only half right. Eisenhower did, in fact, announce a Supreme Court nominee on October the 14th, but it wasn't John Dethmers. It was Potter Stewart. Dethmers' term of office on the Michigan Supreme Court was to expire on December 31st, 1961. Under the permanent Chief Justice law, the court would choose a leader in January of 1962 for the first time in 6 years, and the person they selected would serve until the end of his term. The stage was set for some high-powered politics. The court had boasted 5 Democrats and 3 Republicans at that time. On the day of decision, there was a change in the lineup. George Edwards resigned from the court to take incoming Detroit Mayor Jerry Kavanaugh's offer to become the city's police commissioner, and Attorney General Paul L. Adams was appointed to the Supreme Court by Governor John Swainson. Incidentally, 2 days later, a jovial Irish lawyer from Alpena was appointed to succeed Adams, and Frank J. Kelly was on his way to become Michigan's Attorney General. In light of the Democratic majority on the court at that time, one might suppose that Thomas M. Cavanaugh, the senior member of his caucus, would get the nod to replace Dethmers. Not so. One of the justices who had been nominated by the Democratic Party was Eugene Francis Black of Port Huron. Always a maverick in politics, as in everything else, Black had been a Republican Attorney General and been appointed to the Circuit Court by Governor Williams. Somehow, Gene Black developed a great friendship with Gus Scholl, Michigan's legendary labor and political rainmaker, and in due course was nominated by the Dems for the High Court. While Black was no great fan of Dethmers, he didn't like Kavanaugh either. Or perhaps I should say he liked Kavanaugh even less. So when the votes were counted that January morning, it was Dethmers for, Kavanaugh for. Thus began a standoff that lasted for 3 months. No majority could be garnered for either of the 2 candidates, so Dethmers continued to hold on to the office. The deadlock was finally broken by the newest member of the court, Paul Adams. He switched his vote to Leland Carr, then the senior justice on the court, whose term was to expire in 1963, and a majority supported the nomination. This development didn't sit well with Thomas M. Cavanaugh, respectfully and affectionately known as Thomas the Mighty, or sometimes as Carson City Fats. Tom Cavanaugh was a man who played the game of politics for keeps. When the defecting Adams came up for election to the unexpired term of George Edwards in the fall of 1962, he was opposed by Mike O'Hara from Menominee. As I understood the story, TMK weighed in, behind the scenes of course, in favor of O'Hara, marshaling the considerable clout of the Knights of Columbus, of which Cavanaugh was a state officer, and Adams was put out to pasture. The following April, a duly chastened Paul Adams was returned to the court by the voters. He never again opposed Tom Cavanaugh for Chief Justice. Neither did anyone else in January of 1964. In fact, the record shows that it was John Detmers who moved for Kavanaugh's selection as the first Chief Justice under the Constitution of 1963. The vote was unanimous. Thomas the Mighty was by any measure a strong leader. Self-assurance was his major character trait. He was, in my view at least, wrong on many issues, but he was never in doubt. One of his colleagues, who shall remain nameless because he's still alive, once told me that Tom Cavanaugh knew lots of things that just weren't so. But Cavanaugh was a hard worker, and he set out to put teeth in the new constitutional definition of one court of justice. He took very seriously the mandate to integrate the judicial system. Gene Black was also in favor of strong central control of the judicial system, but he and the Chief Justice came at it from different ways. Black had been a circuit judge before his election to the Supreme Court. He was a workaholic. He had no patience with trial judges who took matters under advisement for long periods of time, and he had the abiding conviction that many trial judges, especially in Wayne County, were loafing too much of the time. With encouragement from Black, Kavanaugh pushed through a Supreme Court rule requiring all trial judges to maintain individual dockets. In Wayne County in particular, the practice had been to use a common docket or general assignment system. When a judge finished a case, he called for another, and the assignment clerk sent the next case on the call. The Supreme Court, especially those members who had trial experience in smaller counties, thought that having a single judge in charge of a case from the beginning to the end would move the docket along better. The court also assumed that there would be more accountability with individual dockets. Perhaps it was the very aspect of accountability that caused the circuit judges to oppose the change. I was on the Wayne County Circuit Bench at the time. Our assignment clerk told us it would take about 6 months to divide up the thousands of pending cases among the 20 judges of the court, assuming that some effort would be made to make sure that everyone had a similar mix of civil actions, divorces, criminal cases, and so forth. I suggested that with 20 judges on the bench, we could simply declare that the general docket would be divided numerically by the last 2 digits of the case number. Cases ending with an odd number and a 1 would go to the first judge. Cases ending with an odd number and a 2 would go to the next judge, and so on. That's what we did, though many of the older judges didn't like it. They complained about uneven distribution of the cases by type. But most of all, they didn't like the annual stories published in the Detroit News comparing the dockets of the judges. Many of them began to keep score, numbers of cases disposed of, average elapsed time from pretrial to trial date, so on. The grousing and the grumbling at the judge's lunch table in the far corner of the county building cafeteria became palpable. Much of this got back to Gene Black, and he began to part company with Tom Cavanaugh. By the time I was elected in the fall of 1966, Black was very unhappy with Cavanaugh as chief and was eager to see him replaced. One of the primary themes of my campaign for the court was the need for leadership on the Supreme Court. I took the Chief Justice to task for failing to control the ad hominem rhetoric that showed up in so many of the High Court's opinions. My chutzpah apparently appealed to Gene Black, and he called me a number of times between November of 1966 and January of 1967. He kept trying to persuade me to let him nominate me for Chief Justice. I kept insisting it wasn't my time. I didn't even know where the bathroom was. Incidentally, I found out where the bathroom was on my first day in the court. In the long evolutionary process by which the state capitol had been remodeled, someone came up with the brilliant idea of installing a lavatory just outside the judge's conference room. It was a very small facility, a one-seater as a matter of fact. But what struck me so interesting was the fact that the commode was built on a raised platform. I suppose it had to do with the installation of plumbing in an area not originally designed as a toilet room. But it looked to me like some kind of a throne. At that time, I recall wondering if it was merely symbolic or if it had been built that way so the judge's robes wouldn't drag on the floor. In any case, Black didn't want Detmers. Kelly wouldn't take the Chief Justice job. Whether Gene Black harbored some ambition to be the chief himself, we'll never know. The fact was that none of the others would have supported him, and he knew it. So Gene and I agreed on Mike O'Hara, and both of us went to work to persuade him to take the job. I worked on Mike to no avail. I flattered him, appealed to his sense of duty, his pride, his ego. He wouldn't budge, but in the process, we became great friends. Mike and Mary invited Polly and me to East Lansing for a football game that fall. It was the very first Big Ten game I'd ever seen, and it was a rather disappointing standoff. Michigan State 10, Notre Dame 10. I recall well the night of January 3rd, 1967, the eve of my first conference as a member of the court. I was still doggedly trying to get O'Hara to agree to be the Chief Justice. We ended the evening at the corner bar at the Jack Tar Hotel, downing stingers and discussing politics and philosophy. I seem to recall we closed the place. The best I could do was to get Mike to agree that he would think about it one more time before making a final decision. Now you have to understand that I had already lined up the votes for O'Hara. Detmers was up for re-election in 1970. Kelly would be retiring then. Governor Romney was in favor of replacing TMK with a Republican. Detmers and Kelly both came to the meeting of the court on January 4th, expecting that Black would nominate O'Hara and that O'Hara would be elected by a vote of 5-3. But about 4 o'clock that morning, the phone rang in my hotel room. It was Mike O'Hara. "I can't take it," he said. "If you and Black want to oust Kavanaugh, I'll vote with you, but you'll have to get someone else to take the job." The atmosphere in the conference room next morning was not exactly convivial. Everyone knew there was mischief afoot, though exactly what was about to happen, none of us could have predicted. As soon as the meeting got underway, TMK announced that the floor was open for nominations for Chief Justice. No surprise, Paul Adams made a short speech in favor of Tom Kavanaugh, then moved that he be re-elected. Ted Suris supported the motion, and the chief promptly called for the ayes and nays. He got 3 votes. For the longest time, he sat there in silence, his face reddening, looking around the table. Finally, he growled, "All right, what are you fellows going to do?" I'm not sure what everyone else was doing, or with whom they may have made eye contact. I was too busy doodling. When I looked up, I saw Gene Black glaring at O'Hara, and O'Hara simply shaking his head and shrugging his shoulders. Finally, Black slammed the table with the palm of his hand, punctuating a curse, and began to address John Detmers, who was sitting directly across the table. "John," he said, "I didn't like the way you did things last time you were the Chief Justice. I voted to kick you out because you never stood up to the legislature or the government. Never really ran things around here, but by God, we can't take another 2 years of Tom's bullheadedness, and since nobody else wants the job, I guess it'll have to be you." Kavanaugh called for the votes, and 5 hands went up. Suddenly, John Detmers was on his feet, tears running down his cheeks. "Just want to thank you all," he began, and then he went into a long monologue about how hard he had worked on behalf of the court from 1956 to 1962, and how he felt that the criticism of his administration had been unjustified. Whatever his faults, John Detmers looked like a Chief Justice. His mane of pure white hair, his deliberate, solemn demeanor, and his deep, resonant voice made him the picture of judicial stature and eminence. But I didn't know then how his personal humility and directness influenced his official conduct. When the State Officers Compensation Commission met in the fall of 1968, the court directed its Chief Justice to make a presentation on behalf of the justices. We were then making $35,000 a year and hadn't had a raise for a long time. I later learned that his presentation before the commission consisted essentially of a self-deprecating, unrehearsed statement that sounded something like this. "Now, I want you folks to understand that I am quite satisfied with my own situation. Mrs. Detmers and I get along nicely on myself. But the other fellows on the court voted to have me come down here and ask you for more money, so here I am." Suffice it to say that the State Officers Compensation Commission voted no increase in judicial salary. I think the day I heard that story was the day I decided to run for Chief Justice. 2 things happened in 1968 to change the complexion of the court. Ted Suris decided not to seek re-election, thus triggering the 1963 Constitution's provision that the court would be reduced from 8 to 7 members whenever the first vacancy occurred. That was one. The second thing was that Mike O'Hara was defeated by Thomas G. Kavanaugh. I have no doubt that TMK was a major factor in the election of TGK. Bearing the same name, Thomas the Good must have seemed to Thomas the Mighty as an apt surrogate to deliver the vengeance properly visited upon those who failed to support him for CJ. Paul Adams had paid the price for crossing Tom Kavanaugh, and so did Mike O'Hara. At the time, I knew nothing of the relationship between Kavanaugh and O'Hara, but I learned of it in a very interesting way. At the December term of 1968, the last day of oral arguments was Mike O'Hara's last day on the court. I tried to organize a farewell luncheon at the Old City Club in the Jack Tar Hotel. Long before I came on the court, the justices had a tradition of dining at the City Club on oral argument days. when TMK was ousted as chief in 1967, he stopped going to lunch with the boys. Anyway, I thought perhaps because it was Mike O'Hara's swan song that Tom might relent and join the rest of us for lunch. He sat next to me on the north end of the bench. I slid a note over to him asking that he reconsider and go with us. He took the note and then turned his back to me and read it. About a minute later, he swung his chair around and faced me, leaned forward, and gave me his whispered answer. "I never blamed you," he said, "but O'Hara owed me, and he knew it." With that, he turned his chair back to face the lawyer at the podium. In the weeks leading up to the January 1969 meeting of the court, Gene Black and I burned up the wires, plotting to get me elected CJ. Gene was close to Harry Kelly, who by then was lame ducking through his last years on the bench, spending most of his winters on Singer Island in Florida. Gene got Harry to commit his support to us, and I was the lineup death march. It wasn't easy. He played a running game of cat and mouse with me, never quite saying no, but never quite saying yes either. I often wonder if he had hopes of another stalemate, which might have left him in the chair for another term. Without his vote, the court would have been deadlocked 3-3. The court didn't meet in January. I can't tell you why. I believe someone was ill, but for whatever reason, the matter of the Chief Justiceship was deferred to February. When the day came, I still didn't know for sure what Deathmarsh was going to do. The governor had sent messages down on my behalf, and John was facing re-election in 1970. I hoped that he had gotten the word. The meeting began with only 6 of us in the room. Harry Kelly was in Florida. He had told Gene Black that he would only participate in the vote if he was needed. In that case, he would send his vote to us through his secretary. Deathmarsh opened the topic of the Chief Justice election. Paul Adams nominated Thomas Matthew Kavanaugh. Black nominated me. The chief went around the table, polling the court. Adams and the 2 Kavanaughs voted for Kavanaugh. Black voted for me, and I voted for myself. 3-2. Deathmarsh summoned Kelly's secretary. In a few minutes, she entered the room and stood nervously at the opposite end of the conference table from the Chief Justice. He asked her if Justice Kelly had instructed her as to his vote for Chief Justice. Yes, he had. And how does Justice Kelly vote? He votes for Justice Brennan. 3-3. Now it's John's turn. He stands up dramatically and begins to recount his service as Chief Justice. Finally, he gets around to the business at hand. Well now, we have 3 Thomases on the court, and 2 of them have been nominated for Chief Justice. There's Thomas Kavanaugh, who has 3 votes, and Thomas Brennan, who has 3 votes. So it's up to me to decide which of the 2 Thomases is going to be the Chief Justice. Well now, let me see. Should I vote for this Thomas? He looks at Kavanaugh. Or that Thomas? He looks at me. There's a long pause while he stands there smiling, looking back and forth from Tom Kavanaugh and me, and obviously enjoying the moment. Finally, he says, well now, I vote for, he pauses, looks around the room again. I vote for Thomas, he looks at Tom Kavanaugh. I vote for Thomas, he looks at me, Brennan. And so I became Chief Justice on a very busy day when the court had a mountain of administrative matters to attend to. I took the chair at the head of the table and began moving the court through its agenda. Lunchtime came. I sent out for sandwiches and we kept on working. Shortly, Don Winters, the court clerk, came to tell me that the press were clamoring for a statement from me. The first they had heard that there was a change at the helm of the Supreme Court was when routine court orders began to be released, which were signed by Thomas E. Brennan as Chief Justice. I told Don to tell the media that I would hold a news conference the following morning. The court stayed in conference until after 5 o'clock that evening. When we broke, the room emptied, justices scurrying back to their offices or up to their cars. Thomas Giles Kavanaugh hung back and congratulated me. He said he would support me and pledged his cooperation. He went on to say that he knew Thomas Matthew was miffed, but he was sure that Tom would come around if only I would extend the olive branch. I agreed and asked TG if he would go with me. We walked around the rotunda and down to TM's office, where we found him sitting behind his desk. He didn't get up when we entered the room, sat in silence while Giles and I stood in front of his desk like a couple of schoolboys in the principal's office. TG made a nice speech about collegiality and how we all had to pull together, and that for better or worse, young Tom Brennan here is our chief, and we're going to have to help him. TM just looked up at him and growled, "He'll get no help from me." That was the end of the meeting. About a half hour later, TG and I were entering the lobby of the Jack Tar Hotel when I was stopped by Al Sander, then a reporter for the Detroit News, later a member of Governor Milliken's staff. He wanted to know why I had refused to meet with the Fourth Estate after I was elected CJ. I tried to explain to him that we had a very long agenda, that I was elected by the narrowest of our margins, and that being young, I didn't want it to appear to my older colleagues that my head was being turned by publicity. Heck, Al, I said, I'd like to get my name in the paper as much as anyone, but I just didn't think it was the right time. I don't have to tell you what the paper said the next day. It was something like, "New Chief Justice seeks publicity." Thus did the teenage Chief Justice learn the difference between truth and news. This vignette has gone on too long. I finished writing it at about 5:45 last Sunday evening in my office on the 10th floor of the new Cooley Center in downtown Lansing. Looking east, I could see the Spartan football stadium. To the north, the spire of the state capitol looms above the Accident Fund building. And looking to the west, I see the law building where the Supreme Court of Michigan has sat since it moved from the state capitol during my term as chief. And further west, the bare steel superstructure of the magnificent new Hall of Justice is rising to anchor the far end of the Capitol Mall. And I think of what an inspiring edifice it will be for future generations of men and women in Michigan. I think of the vision, the spunk, and the perseverance. The Chief Justices Dorothy Comstock Riley, Mike Kavanaugh, Jim Brickley, Conrad Mallett, and Betty Weaver invested in fulfilling a dream that began in the days of John Deathmers and Tom Cavanaugh. Not to mention the ongoing headaches that Chief Justice Maura Corrigan will have as she monitors the construction and plans for the relocation of the court. And then I look to the south. There are no windows in the south wall of my office, just a huge black and white portrait of 7 men sitting behind the bench in the old Michigan Supreme Court chambers. 6 of them look like real jurists, gray-headed, dignified, the wrinkles of hard-earned wisdom verifying their authority and prestige. The fellow in the middle looks too young. But he does look familiar to me. He looks quite a bit like someone who will, the day after tomorrow, be celebrating the 50th anniversary of his marriage to a University of Detroit classmate named Wally Weinberger. These are the times when a man is moved to count his blessings. Mine are numerous and treasured. Not the least of these is the warm camaraderie of this grand society, and I thank Wally Riley and all of you for this chance to stroll down memory lane and for your kind attention.
Well, in 10 years we've gone from the Detroit Club to the DAC, but Tom Brennan has once again done a great job in his latest vignette. So we thank you, Tom. Now we know the rest of the story. I'm assuming by now that you've been able to pass around your table the autographed copy of Arthur Brennan's fictional account of the Michigan Supreme Court, aptly entitled The Bench. Let me tell you, it's a must-read for any Michigan lawyer. Don't miss it. Those of you who have read it already can begin to reflect what Tom said. But it's very, very interesting copy, particularly for Michigan lawyers. One lucky person at each table will take away that autographed copy with the compliments of the author and the society. The losers may purchase a copy of The Bench at the registration table for $25, $10 of which will be a contribution to the society. I want to thank you all for coming, for sharing this day with us. We hope to see you next year. The star on your chair designates the winner. Actually, it's under your chair. We're adjourned, and thank you.